In some ways, you can trace this idea of strict scrutiny actually a little bit earlier than the 1940s to the 1938 Caroline Products case. In the 1930s, the late 1930s, the court was really undergoing a shift in the so-called Lochner era. In the first decades of the 20th century, the court had been incredibly aggressive in policing and often striking down laws passed by legislatures, in particular laws that did things like impose minimum wage or maximum hour or workplace conditions requirements. The court was concerned that those kinds of laws passed by legislatures interfered with economic liberty. And so the court struck down hundreds of these laws in those decades. But by the late 1930s, the court had essentially shifted course and retreated from this very aggressive intervention in second-guessing the handiwork of legislatures. So the Caroline Products opinion marks a really important moment in that shift. That opinion, the law involved is one that had to do with the purity of milk. And what the court basically says is, for the most part, when we're talking about ordinary laws, including, things like the regulations of milk purity, courts should very deferentially review the output of legislatures, the individuals selected by the population to represent them and to enact their wills into law. That's really for elected representatives, essentially, to run the show, and courts should be very deferential and should be very hesitant to strike down the output of the democratic process. But, says the court, and this is where strict scrutiny or some version of strict scrutiny comes in, there are a couple of important exceptions to that general principle that most laws should be reviewed using something called rational basis review, right? So long as there's some rational reason on which the legislature might have acted, the law should be upheld. But the important exceptions to that background principle come into play when a law, 1, violates a fundamental right, 2, discriminates against what the opinion describes as a discrete and insular minority, or discriminates on the basis of protected characteristics like race and religion, or 3, when a law interferes with or undermines the functioning of the political process. All of that reasoning is contained in this very famous footnote 4, probably the most famous footnote in constitutional law. And it basically sets out different types of review that courts should give to different types of legislation. Ordinary legislation, rational basis review, something more searching, what comes to be known as either heightened or strict scrutiny, depending on the specific context, if we're talking about laws that burden fundamental rights or discriminate on the basis of protected characteristics or interfere with the political process. In the 1940s, in cases like Skinner versus Oklahoma and Korematsu, the court uses for the first time this phrase strict scrutiny, basically to explain that under some circumstances where a law draws a distinction, where it either burdens a fundamental right or draws a distinction on an impermissible basis, that law is subject to strict scrutiny. What that means is the law can only be upheld if it is narrowly tailored to, or sometimes necessary to, advance a compelling government interest. So the reason that the government passed the law has to be a really, really good reason, and the mechanism that it has chosen has to be narrowly tailored to advance that goal or purpose. Strict scrutiny means that, for the most part, courts are going to be very skeptical and laws will be struck down, not invariably, but much of the time, whereas that's basically flipped in rational basis review. For the most part, laws receiving rational basis review will be upheld.